Good morning and welcome to Chapter 1, Part 2 with Rob Johnson. I'm Meg Foley, your host and the Professional Development Coordinator for the Board of Building Standards. I have with me today Rob Johnson, who is one of our staff architects, and he is also the person responsible for building department relations and investigations here at the board. Rob knows a lot about Chapter 1, and he's going to share what he has learned and some materials he's developed over the past several years with you. Please give him your close attention, and thank you very much for being here. Take it away, Rob.
Thank you, Meg. Good morning, everyone. Thank you for joining with us today. To continue on with Chapter 1 training, I'll be covering sections 103 and 104, 109 and 110, and sections 112 through 115. So the first section we'll cover is 103, which is the certifications of building departments, personnel and appeals board. It's starting to sound like I'm from West Virginia. Anyway, Section 103, Requirements of Certified Building Departments. The certification rules are found in the Ohio Administrative Code Section 41017 for the following types of certifications for building departments. They are for county, township, and municipal districts. There are three types of certifications that building departments can establish under. The first one is full certification, which basically means that the department does all enforcement authority by certified individuals within their jurisdiction, within their department. Contract certification is simply services being done for enforcement activity by certified individuals, but are under contract. They are not full-time employees of the building department. And the last certification for types, that is sub-department certification. Now, sub-department is a little different in that it has its enforcement exercised on behalf of another certified political subdivision that will perform all enforcement. And they will also include doing the reporting and the administrative duties for that department. Oftentimes we see that sub-departments, there will be primary building departments, which will be the county, and then the sub-departments under them will be other political subdivisions within the county. There are instances where a sub-department happens to be a county associated with another county. So it's a little strange, but that's how sub-departments are set up. Now with certification, just as you'll see with building departments and personnel and boards of appeals, there's a complaint process. The board has allowed any individual adversely affected by the enforcement actions of departments or personnel or even boards of appeals, meaning local boards of appeals, for that individual or even that group or other entity can make a formal complaint to the Ohio Board of Building Standards. The board then has the opportunity, after an investigation is done, to take an action which could result in revocation of their certification as a building department, or suspension, or perhaps probation, which oftentimes requires additional education, if you will, by the Ohio Board of Building Standards to the department. One thing I want to point out here is that building department certifications are actually owned by the elected officials of the political subdivision. This is not something that's owned by the building official or anyone else. This is enacted legislatively by the local district who requests the board to have a building department. And this is key because even though the building official holds a lot of responsibility, it's actually, in terms of maintaining the certification of the department as a whole, The people who are responsible for that maintenance are the elected officials. And then there are some special departmental requirements that are addressed in 41017 with regards to certifications of building departments, such as changes in jurisdiction, or perhaps the surrender of the certification. If a department can no longer be profitable, or the elected officials decide that they would rather be a sub-department or just not have a building department, period, they can surrender their certification. This is problematic, obviously, with residential enforcement, in that if a department basically ceases to exist, there's no other entity that has jurisdictional authority. In the cases of commercial, it's different. If a city, let's say, would surrender its certification, or a county, the state building department still has the opportunity to do the enforcement for that jurisdiction. And of course, shared jurisdictional authority. It's unique, but oftentimes we'll hear about projects that actually straddle the boundaries of jurisdictional areas. And so it's up to the building officials to determine, and sometimes the elected officials, to determine how that project is going to be enforced. So let's move on to personnel. With personnel, there are 3 certification types. There's the full certification, which means that the individual is able to do all their duties and responsibilities under that certification. There's interim and trainee. Trainee basically means that someone who does not and has not fulfilled all the certification requirements can work in a building department as long as they are being mentored and that reporting is being done as to their development. Oftentimes, graduate architects or engineers who are not yet licensed will fall under this certification. An interim is the certification that is granted to those who meet most of the requirements but haven't passed their tests yet with either ICC or NCI in order to secure their full certification. So once personnel receive their certifications, they do have the responsibility to maintain that certification. They need to renew annually. They need to do continuing education. And just as I mentioned with building departments, there is a complaint process. So if personnel are performing their duties in ways that adversely affect owners who are doing buildings, anyone can submit a complaint. Complaints come from lots of different places. Sometimes they come from other certification holders, such as one inspector complaining against another inspector who is doing things improperly. But whatever the case is or the source of the complaint, the board will investigate it. And if there are grounds showing that the certification holder is in violation of the board's rules for certification, the board can act to either revoke or suspend the certification holder or put them on probation. Probation is the best thing because we're looking to see a correction by the certification holder so that they can keep their certification. Then local boards of building appeals. Their certifications are different. This is not the state that is the Ohio Board of Building Appeals. The state has jurisdictional area over all places in the state for commercial projects, except for those areas that have certified, that is Ohio Board of Building Standards certified local boards of appeals. With these appeals boards, there is a requirement for composition of the board members and their terms. And as I indicated before in the previous 2 certifications, there is a complaint process. So moving on to section 104, let's talk about duties and responsibilities of certification holders. We're going to be specific with regards to personnel now. A building official has duties that are conferred to him or her that no other certification has. A plans examiner or any type of building inspector will not be doing any of these responsibilities or duties unless they personally hold a certification and they're a backup or a sub building official under the building official having jurisdiction. But these are the duties, and this is the general duties of a building official. They are to enforce the rules of the board as found in the Ohio Revised Code 3781 and 91. This is the law or the statutory regulation that establishes building code enforcement in Ohio. Building officials to adhere to a prescribed manner of conduct, meaning that they need to be professional, courteous, impartial, and responsive, and cooperative. As the authority having jurisdiction, they are the ones who render interpretations of the code. Building inspectors and plans examiners do not have that right. They are to adopt building department policies and procedures per the code, meaning Chapter 1, and assure a system is in place to track and audit all projects. This is active tracking and auditing. Now, the building official that's in a very large jurisdiction may not be able to do that, but they at least need to know who to talk to and where to go to if anyone needed information on a project. And the building official is responsible for assuring that all personnel, meaning personnel of the department, that would include the certified plans examiners and the inspectors, that they perform their duties as required. And the building official has the responsibility for overall administration of the department program and the protocols. Now let's look at some specific things that the building official is responsible for. To receive plan approval applications and construction documents. Building officials to cause those plan examinations to occur to determine conformance to the code. They are the ones who issue plan examination reports for non-compliance. They are to coordinate the plan reviews among elective plans examiners. You may have more than one plan examiner in your office. The requirement is to have a master plans examiner, but you may also have an electrical plans examiner or a plumbing plans examiner. And if so, the building official is to ensure that those plans examinations are coordinated together. And the building official has the responsibility to approve or deny the request for a plan approval in 30 days. I wanted to make a point here that 30 days is oftentimes interpreted as this is how long that the plan examination can occur. But the reality is that the 30 days represents an approval or a denial. So there has to be further action beyond the plan review so that the building official has given a decision to the applicant. The building official is to issue all orders for non-compliance per Ohio Building Code Section 109. This is adjudication orders. He's also responsible to cause inspections and investigations to assure compliance. And during inspections and investigations, the compliance is actually to the approved construction documents, not to the code. And the building official is to maintain department records and submit department reports. And those, generally speaking, are the ones that come to the board. That's going to be your 1% and 3%. It's going to be the yearly operational reports and any other reporting that the board requires of the building official for the department. Ultimately, you'll see that duties and responsibilities can be summed up in one word, and that is communication. Plans examiners. This is for master and any elective plan examiner. Your duty is to adhere to this prescribed manner of conduct. You have to be professional, courteous, impartial, responsive, and cooperative. Your responsibility is to examine construction documents to determine compliance of the design with the code in accordance with your certification. The master plan examiner can review all types of of building plans. Pardon me. But if you're just an electrical plans examiner, you're only reviewing those documents to the code for electrical only. And plan examiners have to effectively communicate their findings to the building official. Now in section 107, you've already learned this morning that most likely that communication needs to go to the building official, but oftentimes it goes to the owner or to the designer of record. And that process is followed in a little more of an informal approach. But ultimately, the building official needs to be aware of it. Remember, he's supposed to track and audit the project. Again, to sum it up, it's communication. Inspectors. This is building, plumbing, and electrical. This is meaning these are the required certification holders for inspection of every department. And then elective, so there may be mechanical or other types of inspectors that are employed by the department. Either way, all inspectors are also to adhere to this prescribed manner of conduct. You're to be professional, courteous, impartial, responsive, and cooperative. The responsibilities of an inspector are to perform inspections, to determine compliance with the approved construction documents in accordance with your certification. When you've done that, you effectively communicate the results of the inspections to the building official. Now in real time, we know that also occurs with the contractor or the site supervisor while you're on the site. And tomorrow, inspectors, I'll be teaching your session. We'll talk in greater detail on how that's done. Again, to sum it up, it is about communication. So let's talk about personnel liability. We won't go into great detail on this, but I do want to explain this. Liability of certified building department personnel for any tortious act will be determined by Ohio courts to the applicable provisions of Ohio Revised Code Chapter 2744. There's a couple things to keep in mind. When you think about the manner of conduct, oftentimes that's the thing that gets, if you will, violated, that causes some interesting things to happen if the jurisdiction is sued or if you are sued because of your enforcement actions. You need to understand that the manner of conduct is very, very important when it comes to perception with the people that we interact with in the public. An employee has immunity unless his acts or omissions were manifestly outside the scope of his official responsibilities, or his acts or omissions were with malicious purpose, or in bad faith, or in wanton or reckless manner. An employee is defended by the political subdivision, but you may be financially responsible if you do not prevail in the case. It's going to be up to the jurisdiction. There is a statute of limitations for any action. Must be commenced within 2 years after the cause that the action occurred. So let's talk about the duties and responsibilities of appeals boards. Appeals boards have powers to render determinations of appeals from owners. They are commercial only. Now, oftentimes local boards of appeals that happen to be certified by the Board of Building Standards also will be under contract with jurisdictions to do the residential. But in terms of the certification of a local board of building appeals, it is only conferred for commercial only. As you know, residential must have an appeals mechanism at the local level. And oftentimes that's done by zoning committees, or could be planning and development committees and boards. Whatever the residential makeup is what it is. The board does not have any authority to regulate at that level. And there's a composition required, which is qualified representation for a commercial local board of building appeals. Again, meaning an appeals board that is certified by the Ohio Board of Building Standards. So just talking briefly about this, the powers of the appeals board is to hear and decide adjudication orders issued by the building and fire department officials. It can determine to reverse, modify, and or uphold the adjudication order. And I guess
Good morning.
and make sure that your microphone is on mute. Thank you. So the order, if it's contrary to such laws and rules, this is to be able to hear and decide adjudication orders. The appeals board can also determine if the order is contrary to a fair interpretation or application thereof, or that a variance from the provisions of such laws or rules in a specific case will not be contrary to the public interest, or literal enforcement of such provisions, meaning building code provisions, will result in unnecessary hardship. So basically, the appeals board can render an interpretation, they can change the order, meaning reverse the action of the building official and that they disagree with the building official, or they can support it, or they can grant a variance to a code provision because the designer or the owner has shown that they have been able to prove, that is, that they have met the intent of the building code provision that's being adjudicated. As I mentioned, there are two types of appeals boards. If there is no local board of a building appeals that has jurisdiction in your political subdivision, then you're going to go to the state board of building appeals. Here's the difference. Local boards of appeals are certified by the Board of Building Standards. That if there are further appeals after the local board of building appeals has made a determination, those appeals can go to the Court of Common Pleas or to the State Board of Building Appeals for a de novo hearing, which basically means a brand new start for the applicant. The state's Board of Building Appeals is created statutorily. It's not something that's certified by the Board of Building Standards, but it's created in the law. They conduct hearings for political subdivisions that without local boards of appeals. And if there are further appeals at their level, they will go to the courts also. Composition of those boards, both have 5. There's a little difference with the State Board of Appeals, but for this discussion, we're just going to talk about the requirements for the board certification. There must be an attorney, there must be an architect, there must be a structural engineer, must be a mechanical engineer, and there must be an individual that comes from organized labor who is familiar with construction and equipment in buildings. So we talked about violations of duties briefly earlier in the complaint process when we discussed different certification types. The handling of improper actions by any type of certification is done in the following way. They must represent violations of duty, which are improper actions. The action can be taken by the building department personnel, or a local board of building appeals. Any person, that means anyone in the state, that's affected by the improper action may file a complaint with the Ohio Board of Building Standards. Complaints are processed as outlined in the Ohio Administrative Code section 41.17, and complaints, if represent violations to the board's rules, are investigated. Upon findings, the board may decertify, suspend, or discipline by probation with conditions, or they can still choose to dismiss the complaint. So I wanted to sum this up as a primer, if you will, on why all these certifications are necessary. There's a purpose behind it. Owners who want to design and construct buildings in Ohio need to make them safe. But the owner owns this process. The board sets it up, we administrate it. You as the personnel of the departments follow the board's rules to enforce building codes. But the owner is the one who ultimately makes all the decisions. So let's look at that real quickly. This process ultimately means that if the owner wants to build a building, eventually he'll want to occupy it. And that's how the whole process ends, is a certificate of occupancy is issued. But to get there, there has to be some code compliance achieved. So on the far right hand side, you'll see an O that's highlighted, which means owner. These are all the places that the owner is involved. They steer this process. So applications and construction documents are submitted for approvals to the building department. The owner does that. They're the ones that actually initiate this process. We don't do it. Plan reviews are done to establish code compliance of the design. That's the plan examiner's involvement and the building official. All content of correction letters and orders are incorporated into the documents. This is the owner revising and resubmitting based on violations found in the design when it was compared with the building code. And then if there was any appeals, all variances and conditions are incorporated into the design. Once all those checks have been checked off, once all those boxes have been checked off, the certificate of plan approval is issued by the building official to the owner. You notice I put a little note underneath there. It says other permits may be issued for site, etc., including approved construction documents. Your jurisdiction may have something called a permit, which is something different than the certificate of plan approval. The certificate of plan approval is only communicating this, and that is the design is code compliant. That's all that it's doing. But in terms of site development, there may be 5 to 10 more different types of approvals that are done at the jurisdictional level, such as zoning, engineering, planning commission, utilities, etc., etc. So your permit basically acts as what I've heard a lot of building officials call a blanket permit. It captures all approvals that are done so that the owner can then commence construction to build a code compliant building on an approved ordinance compliant site. So they both and all work together. Once that CPA is issued, then the building official authorizes inspections to be done. These are required inspections found in section 108 of the building code. The inspectors verify the work complies or matches, that's a good way of thinking about it, that it matches the approved construction documents. So that's the inspectors, and it's also the responsibility of the owner that that happens. Certifications of tests of building systems are completed and submitted to the building official. That again is the owner. They're the ones that, or their representative, you know, so it's either designers, contractors, but it still ultimately is the owner who's under contract with those individuals and those companies. And then all variances and subsequent approvals are inspected and compliant. It's great to have one certificate of plan approval, but oftentimes there are many. You can have phased approvals and have 10 different phases and 10 different approvals all under one master approval. So required inspections need to be coordinated between all these phases and disciplines, etc. Once all those required inspections have been done because of the completed work, that is the construction, then the certificate of occupancy is issued for the building to the owner. That's important. Certificate of occupancy is issued for the building. That's why when you look at the requirements of a certificate of occupancy, you will not find the owner's name in there. The owner can change. Tenants can change. But the building remains the same as long as it's maintained the way it was originally approved. So make sure that the C of O is issued for the building address. If you want to put the owner's name on it, that's fine, but it may be invalid after a number of years if the ownership changes to the building. So to keep it clean, just make it for the building. Section 109, orders, violations, and unsafe buildings. This is the process for enforcing the rules requiring compliance with the code. So the department has to communicate. The process requires actions to be taken to achieve compliance for safety and sanitation. It protects Ohio citizens' rights to due process, to receive a proper order. It allows appeals by them to access the courts or to boards of appeals, whichever is the case. And prior to taking any action, civil or criminal, the building official must first issue the adjudication order. So these are the parts of a valid adjudication order: the name and address of the owner, the address of the property or the project, the specific citation. This has to be specific code section or a section of the law that's in violation. An indication of the actions necessary to resolve the issue. Now, this is just based on getting it to be in compliance. It doesn't represent your interpretation of what you think needs to be fixed. It's what is required by the code and what is deficient and what needs to be done in order to get them to come together. So the description of this appeal is of the appeal procedure needs to be in the order if it's requested, and the owner has 30 days from the date of that adjudication order issuance. So the owner must be responsive. They can waive their right if they go to 31 days. They no longer have the right to appeal. There must be an explanation that the owner may be represented by counsel and present arguments either in writing or orally. And the building official needs to indicate a reasonable period of time for the owner to comply. Let's put it this way, if you don't think you could get something fixed in 5 days, then why would should we put that expectation on the owner? It has to be a reasonable period. And then the adjudication order has to be numbered, the building official has to sign it, and it has to be sent to the owner or the representative that's accepting it. The results if the right to appeal an adjudication order are not exercised. So the owner waives their right to appeal. That means they can't go to the appeals board, but it does, here's the issue. It allows the owner to be prosecuted. So if it's a serious hazard and it's a danger to people, then that order has to be done. The owner has to be responsive. They have to abate the unsafe condition. And if they don't do it, then your law director and your prosecutor are going to step in and begin a legal process. It causes the owner to be subject to a fine of not more than $500. My understanding is that that is not a daily amount, that's just a final amount. And that's per the Ohio Revised Code 379104. So we don't treat this like liquidated damages, we just think of it as a penalty for not having responded to the order. And a failure to cease work after receipt of an adjudication order is deemed to create a public nuisance. So if you were told to stop work and you continue working, there's a very good chance you're going to be prosecuted. Addressing unsafe buildings. Considered a serious hazard if it is an unsafe or unsanitary building due to risk. So if it's considered unsafe if people can't be in it safely. So if there's inadequate means of egress, or inadequate light and ventilation, or a fire hazard, could be a structural hazard, could be an electrical hazard, whatever the case may be, the hazard must be eliminated or the building must be vacated. This is, again, to keep the occupants safe. If, after being vacated and the serious hazard remains, this, again, causes the building to be considered a public nuisance, the building official can enter into adjudication orders and cause the building to be razed. I'm sorry, I meant to say injunction proceedings. Steps to take when an owner fails to eliminate a serious hazard. The building official can seek an injunction. The injunction process is prescribed in 3781-15, and it basically says any building which is declared to be a public nuisance may be enjoined in a proceeding instituted in the name of any department or officer in a court of common pleas. The owner can respond to the order by restoring the structure to a safe condition. Restoration must comply with the appropriate section of Chapter 34 for repairs, alterations, additions, and change of occupancy. So we've been talking about appeals in terms of appeals boards. The hearings themselves have to follow what the Ohio Revised Code says. So a Board of Building Appeals must schedule a hearing to notify the appealing party of the hearing. They may also require attendance of the witnesses, a production of documents and records, and may also include depositions. Anyone testifying must be under oath. There must be a stenographic or mechanical record of testimony and evidence. The board may choose to continue the hearing, and the board must keep a full record of the proceedings. So conducting hearings by the local Board of Building Appeals, you must render your decision within 30 days of the hearing. You can't wait beyond 30. You have to be responsive. And you'll notice in the building code that 30 days comes up a lot. It's basically the length of the court between owners and the enforcement agencies. So, you know, you have 30 days to review the documents and approve or deny the approval. You have 30 days to exercise your right to appeal if you receive an adjudication order, etc. So it's a kind of a legal timetable that we follow in order to ensure that everyone is being responsive to communication that's going back and forth. The appeals board must issue a certified copy of the order explaining the time frame and method of complying with their decision, and must mail a copy of the order to the attorney or representative. Provisions for conducting adjudication hearings by a certified local boards of appeals if the appeal concerns accessibility. So if you have an accessibility appeal, a reasonable notice must be given to either the local organization representing the disabled or any statewide organization representing the disabled if no local organization exists. So we're talking about ADA requirements. The folks that make the appeals need to have their advocates involved so as to ensure that there's a technical discussion, if you will, over the requirements that are under the adjudication order that are asking to be appealed. And the notice must include the time, date, and place of the subject of the hearing. Provisions regarding appeals of a decision of a certified board of appeals. Any party to an adjudication order may appeal. That would be designers, contractors, the owner, any other representative. Appeals involving accessibility issues may be appealed by that local organization representing the disabled or a statewide organization. And further appeals can be made to the Ohio Board of Building Appeals within 30 days of the decision, which is the de novo hearing. Again, the de novo hearing basically is a reset, a restart to hear the case over from the beginning. So there's no precedent being analyzed by the previous appeals board. They are just starting it over. In the Court of Common Pleas of the county of the appellant or in which the project is located. Changes to the code. Anyone can propose a change to our building code. The outline of code change process is found on our board's website. The Board of Building Standards may act on its own motion to change the code, and code users may submit a code change petition. It must be submitted on the form prescribed by the board that is found on our website, and it must be submitted for adoption, or may be submitted for adoption, amendment, annulment, or rescission. Meaning you may want to adopt new language, amend existing language in the codes, or annul or rescind. Rules in effect on the date of the first application for approval must be used for the plan review and inspection. I'll talk briefly about industrialized units. Definitions used to describe this program. Closed construction. An assembly manufactured in a manner that its structural, plumbing, electrical, environmental control, and fire protection elements or components are concealed. That's the key, that they are concealed and not readily accessible for inspection at the site without disassembly, damage, or destruction. Industrialized units are prefabricated components that are made of closed construction, manufactured at a location remote to the site of its intended use, and it's transported to the building site for its subsequent use. What that means is that there's going to be site-built construction to accept one of these units. So we need to talk about the industrialized unit program that's with the Division of Industrial Compliance at the state of Ohio. Industrialized unit manufacturers and the application to participate in the program is the identification of third-party inspection agencies under contract to provide evaluations and inspections. You also need to identify third-party inspection agency employees holding appropriate board certifications who will be performing in-plant inspections. There's evaluation of applications to participate in the program. A review is done of each of the manufacturer's facilities. A review is done of the manufacturer's quality control program, and a review is done of any sub-assembly plants. Once all that has been completed, approval as an Ohio IU manufacturer occurs. Once it's recognized, the manufacturer can submit construction documents electronically for approval or for in-plant construction to the Ohio Industrialized Unit Program. In-plant inspections, insignias, and shipping reports. So certified IU inspectors review in-plant construction for compliance with the approved construction documents. You'll notice that is very similar to just regular building code enforcement. That's what the inspectors are doing on the site. They are checking for compliance with the approved construction documents. Upon completion of the compliant in-plant construction in compliance with the approved construction documents, once that's confirmed, the manufacturer is authorized to obtain insignias, meaning like badges, from the Board of Building Standards. Those are issued and they will be put on the actual module, the industrialized unit. That's how you, inspector, as you go out and you're there to see the connection of a delivered industrialized unit onto the site, onto site-built foundation systems on the existing site, That's how you're going to verify if that unit has been approved by the Ohio Industrialized Unit Division. If it's not there, tell the building official who needs to contact the Industrialized Unit Division that fraudulent work is being done. But if it's approved and it has received its insignia, the IU can be shipped and placed anywhere in Ohio. Forgot to mention manufacturer's responsibilities. Manufacturer is responsible for ensuring that all that process is followed, as well as their own in-house compliance programs. The building codes are complied with because they are submitted, just like with any other building department, to the Industrialized Unit Division for that certificate of plan approval. Section 114, product and materials. Any material, product, or assembly or method of construction shall be approved by the building official. The provisions of this section describe the product approval process intended by the Board of Building Standards. So there's some important definitions to know here. Accreditation, it's a recognition under a quality system. An accreditation body verifies technical competence for conformity assessment bodies who perform services for compliance. This represents conformity assessment bodies, that is, look like this. They can be testing labs, product certification bodies, which do listings and evaluation services, inspection bodies, field evaluation bodies, fabrication inspection bodies, special inspection agencies. Those are Chapter 17 special required inspection agencies, and calibration bodies or labs. The board also recognizes industry trade associations. These are specific member industry quality assurance associations. And then recognition. So they have to be recognized by the board. They fill out an application. They send in their information with regards to their accreditations, the type of conformity assessment bodies that they represent, and all required paperwork, including their certificate of accreditation and their scope of accreditation. This is basically our quality checklist that we use to ensure that materials, products, assemblies, methods of construction are per the code and per reference standards. So the organization of board recognized conformity assessment bodies and trade association certification programs. Now, I know I'm probably overwhelming at least half of you here, but this is especially important for building officials. In section 114, we have this diagram that indicates exactly what needs to occur in terms of when you receive reports, such as evaluation service reports or testing lab reports, things like that, that you're assured that the agencies that are producing those reports are qualified to do so. So we just recognize their accreditations. We don't approve anything here. We just recognize the current status of any and all of these bodies that are represented in this chart. So the accreditation bodies accredit all these different types of agencies, with the exception of the Industry Trade Association to the far right. They are approved based on their own quality assurance programs within their industry. We're talking about precast concrete, steel manufacturing, those type of industries. That's what's represented in the industry trade associations. All those other agencies underneath that are accredited are listed here. As you notice, product certification bodies actually have two different arms that they can do. They can do evaluations, and what that means is that they're evaluating products or assemblies of products and or materials that the building code doesn't directly speak to in terms of enforcing the requirements for it. So what the evaluation service does is they take the building codes that are affected, they get additional testing done, and then they verify that it meets the intent of certain building code provisions in the code so that the building official can approve those materials, those assemblies, those products and methods. The listing agency is real simple. They just ensure that things have been tested, that products have been labeled or listed, and so that you as the inspector, when you see doors out on the site, when you see those tags on the butt end of the doors where the hinge is, that it'll have the appropriate UL listing. The label will also indicate its hour rating, and that's how we assure that products that are listed have been approved, that they meet the reference standards found in Chapter 35 of the Building Code, as well as the provisions of the Building Code itself. So the building official has an approval process for these materials. The methods are prescribed in the code. So you'll be receiving things from testing labs, listing agencies, evaluation service agencies, etc. For those things that are not listed in the code, as I said, evaluation service reports come into play. Specifically, ID and description of the product, specific code sections to determine equivalent compliance, installation requirements, a statement of conditions and limitations, and list of tests used. We also have in section 114 a specific list of everything required in evaluation service report. If you do not see those things in that report, let us know. We can contact the evaluation service agency and their accreditation agency to ensure that they're following the board's rules. Used materials are allowed on projects. They have to be approved by the building official. That may mean that the building official and an inspector need to go out to a storage area or to a job site to inspect those materials to ensure that the quality is there. There's other ways of also verifying the condition of those materials through the use of conformity assessment bodies. So the last section here is about the organization of the board, section 115. The board is comprised of 3 committees or subcommittees. They are made up of a combination of all the board members on the board. And these committees make recommendations to the full board membership. The code committee provides general oversight of the board's rule promulgation and code development activities. In other words, if there's things specifically about the building code that need to be addressed, the code committee meets to discuss those things. So the committee reviews proposed rule changes, which we're doing right now, and petitions for code changes. So petitions can come at any time. The proposed rule changes often come in 3-year to 5-year spurts. But the code committee is responsible for that involvement and for that guidance for the full board. The education committee provides general oversight to the board's continuing education program. The committee reviews continuing education course applications submitted for approval, and this program today is actually managed by our education committee. Certification committee. They provide general oversight to the board's personnel and building department certification program. The committee reviews personnel and building department certification applications, and I failed to include boards of appeals, local boards of appeals applications as well, and that are submitted for approval. The certification committee relies on your records. So there are reporting records that need to be done by the building officials. That record represents a database that we access all the time. So the yearly operation reports will have the listing of all the personnel and the major activities, including adjudication orders being issued and how many appeals have been done in the following year, or in the previous year, excuse me. But the certification committee provides general oversight for the certification program itself. So anytime there's anything, especially in section 41017, with regards to the certification requirements, the certification committee heads that up. So this concludes this session of Chapter 1. I just want to say thank you for your patience and for listening in on this. I know this is a lot of information that's coming at you, but take heart. Eventually this stuff will become secondhand nature to you. I recommend that you read Chapter 1, that you get accustomed to referring to it. As we get into the breakout sessions for inspectors and plans examiners and building officials, you'll see why Chapter 1 makes such a difference. So that concludes this session. I just want to say have a great day, and I'll catch you, the inspectors, tomorrow. Thank you.
Thanks, Rob, for a really informative presentation. We appreciate your time on this and for such excellent instruction. We will take a break. Office hours, if you have questions for staff, will be at 12:30. And for those of you who are in the plans examiner breakout, that will begin today at 1 p.m. If you are in the inspectors breakout, that will be tomorrow morning at 8:30 a.m. And if you are in the building officials breakout, that will be tomorrow afternoon at 1 p.m. Thank you very much, and this ends the program.